and the PA are both called contracts where they are binding upon the successor trustee to act in accordance with it. So the successor trustee doesn't have the authority to change something that the original trustee entered into during their lifetime. So in other words, if they sign a listing, the successor trustee can't say, oh, it's no good, I didn't sign it. It's still binding. Same thing with the PA at that point. The successor trustee is bound by what the original trustee did during their lifetime. Those situations have occurred at least 3 times this year that I'm aware of, where I've had to deal with the successor trustee thinking they had more authority than they did. And usually I could talk to their attorney and it's pretty quickly taken care of. But in those situations, it's best to try to find out who the attorney is. Let me talk to them directly. It usually resolves the issue a lot quicker than trying to argue with the successor trustee who thinks they have authority that they don't at that point. Any questions on the trust? Because this is something that we're seeing more and more, and we're going to see more and more of as people do more estate planning work. Good. But this is kind of just a quick primer on it. Powers of attorney is another huge area. There are 2 kinds of powers of attorney. One is a general power of attorney, where we'll say, I give Cheryl the authority to act on my behalf. That is good so long as I am living, or until I reject it. If I pass away, she has no authority. If I'm mentally incapacitated, she has no authority. If I'm physically incapacitated, she has no authority under a regular power of attorney. A durable power is what is part of most estate planning packages right now. A durable power endures through my mental inability to act or my physical inability to act. However, same as with a regular power of attorney, if I pass away, she has no power. And same thing with the listing and the PA. They're binding upon the estate of that person, of me, if I pass away, so long as Cheryl entered into it as my power of attorney. So those are still good agreements. The deal doesn't fall by the wayside because I passed away. If there's an executory contract still in place, my estate is bound by those terms. Now, if that PA falls through, or you're going to have a counter to it, or going to make some adjustments, then we have to deal with the estate.
So then the durable power of attorney, even though the decedent, now there is a decedent, whoever was durable power will hold because that was in existence prior to the death.
Anything they entered into
Was, okay,
is binding upon the estate.
gotcha. Not,
Right.
Right.
Can't do anything new, but what's there is good.
I have a case where, she was like, he signed a listing agreement. But since then, the son signed, he has dual power of attorney. He signed the purchase agreement. My actual seller died on Sunday.
That's no good anymore. So,
Okay, well, the reason.
yeah, the listing may be binding at that point, okay?
Well,
Because it was entered into during their lifetime.
but the purchase agreement was signed by their.
Oh, while the decedent was living? Oh, I misunderstood. I'm sorry. Yeah.
Yeah, so now,
that is a good one, but you have to still open an estate, but the estate is bound by the terms of what that was entered into.
okay.
Yep.
Bill, here's a question on that.
Uh-huh.
So when we open that, this is something that's actively going on. Is that something that the person that was the durable power of attorney could be named a unrestricted or get unrestricted letters of authority, or is that something that may have to go through the entire probate court process?
At that point, it will be unrestricted because the only purpose to opening the probate is to fulfill that which they entered into during their lifetime. Now, again, if you change the PA or whatever, then you have to go back to having something done at the probate level for approval. Now, in probates, which is the next topic, there are estates that have to be supervised. Those are the usually special circumstances, like the heirs are arguing and can't agree on what will be done, or they're saying the trustee is doing some self-serving things, and the personal representative is kicked out because they're doing personal things. Like if the personal representative executes a deed to themselves from the estate to themselves individually, that may be okay if the will specifically provided for that. If the will said, this property is to go to my son, Jason. Period. Okay. Doesn't matter that Jason is the personal representative of my estate. It's still good because it was provided for specifically in the will. If it was not provided for, and it's a self-dealing, then there needs to be the blessing of the court on that deed from Jason, trustee deeding to Jason individually. So sometimes we run into that where parties are trying to do something real quick, and they can, but as long as the will says they can do that. So those, we need to get a copy of the will, not just the probate part to it. So keep in mind that the will does not mean anything until it's accepted into probate. You can say everything under the sun, but until it's accepted into probate, it's not a viable legal instrument at that point. So if the will says that the person's to be a personal representative, the court has to also say that by accepting the will into the estate. Now, we are seeing a lot more situations where the people want to keep it in the family, or somebody has put out a lot of money to take care of the now deceased person, and they're to get an early allocation by agreement amongst the heirs. That's fine, but that should be done with the money, not with the title. So the personal rep, we'll say, sells a house for $300,000. That money goes into the probate estate, and somebody has advanced $77,000. The probate court will take that as a claim, and that $70,000 goes out of the 300 before any heirs get any money in that, because it's a claim against the estate. Now, one of the other things about an estate that's coming up more and more often now is you have to tell everybody who's a claimant that they have to file their claims. And guess who's showing up quite a bit? The IRS. And if they happen to be a student loan party, they're a party of interest who gets their money before the heirs also. So we're seeing a lot more what I call interventions, but it's not something that affects our conveyance of title. It has to do with how the money is distributed. If they have claims totaling $700,000, we sold the property for $300,000, so what? That does not affect the transaction, because that's a claim against the estate. It's a personal claim. It's not a claim against the property unless they have filed a lien on the property itself. But that's coming up quite a bit more too, because of the student loans are accumulated quite a bit in terms of the interest that there is on those, where people have just ignored totally paying them. It kind of comes out at that point, and it's one of the parties that has to be given notice now for an estate. It didn't used to be, but now it is, especially since they're now enforcing it on it. Even during the COVID period, they still would enforce against an estate because there's no longer any deferral of the payments because the person has passed away. This is the time to collect, and so that they are showing up as a creditor of the estate. But again, that means nothing to you. I got more than one panic-stricken call. The IRS and the student loan people are saying that they get the money, not my party. What do we do with the closing? No change on the closing. We just put the money into the estate and let them fight it out. And sometimes the agents from the IRS could be a little persistent would be the polite way to put it, and insist that they have first right. They may have first right to the money, but they don't have first right to the property unless they do in fact have a lien on the property before, before the estate is filed. I'm pretty clear on that because that one's one of those that, oh my God, we got a problem. No, you don't. It's well, sometimes we have to talk to the parties because the purchaser's attorney may not be familiar and gets very concerned that his client is not getting clean title unless we officially take care of the IRS or the student loan collectors. And no, that doesn't have anything to do with it. It has to do with the seller's attorney and how they disperse the proceeds from the estate. If they disperse the proceeds to the heirs and ignore the IRS and the student loan collectors, yeah, they got a problem. Is that lien follows the money when it's distributed to the heirs. So it's the heirs are becoming more knowledgeable about this because of the interventions that are occurring more and more often. Now, what I put together is just a brief outline there on the title requirements for when we're dealing with both trusts and an estate. Now, if it's a supervised estate, this is where there's an argument amongst the heirs, or there's no will, or whatever the case may be. The court does have to give a blessing to the purchase agreement. Now, the purchase agreement has to give a blessing to that purchaser for that property for that amount under those terms and conditions. If those change, you have to go back to the court to get another blessing on those changes. Now, rarely does that cause any problem in terms of it, unless there's a dramatic reduction in price or a dramatic amount of concessions or something that would affect substantially the amount of money that the estate's going to get from the sale. That's the, so once you get your order approving sale, try not to change the PA because you're delaying the closing if you change the PA at that point. You have to go back in for another date. Now, one thing I did not put on here that's become a strange problem, but more and more of the probate files are being done by Zoom. And so, and by email documents. Well, the problem is that the Register of Deeds doesn't recognize email documents for recording purposes. So the letters of authority are not original signature or anything like that. We've actually had to, at least Oakland County, we have a problem, but because they won't let us take an affidavit and attach the documents. Okay, Wayne County and Macomb will. Oakland County, well, I shouldn't say Oakland won't. Most times they won't. Depends on who's reviewing it. So sometimes they want originals and you can't get originals. So we have many times had to ensure without having those documents being placed of record, because we have them in our file, because there is just no physical way to get, to convert that email document to original ink at that point. And the judges aren't very amenable to bringing it back in to get ink from them. I already signed it. Yeah, but it was an email transmission of the copy of it, not the original ink. So the old statement about needing the seal on it, that doesn't occur very often either anymore. Now, upstate, yes, they put seals on everything because that's just the way they've always done it and they don't change and they're not very electronic. So it's that's just actually a practical problem for us, getting documents that we can record. So if we're asking for some different things at different times, that may mean we need to get it at least into our file so that we have it. So as an insurer, if necessary, somebody brings an action, we can bring them in then to the court file, but we can't necessarily get them of record. Is one of those things. We have a Register of Deeds in Oakland County. She was a politician and remains a politician, not a Register of Deeds, okay? And the worst thing you can do is ask her, because she hands off on the Register of Deeds, which is probably good. Anytime she has spoken, it's like, oh my God, she didn't just say that. It causes us some problems because people think she saying how it really is, and it isn't. So just keep that in mind if you hear that, well, I heard the Register of Deeds speaking, they said this. Well, you got a high probability of being wrong at that point. Okay. Any questions on either the trusts or the estates?
We've seen a lot more personal residences being in trusts.
Yep.
Can you talk a little bit about because there have been some municipalities, especially where they have then tried to uncap those properties. Can you talk a little bit about how trusts relate to uncapping and capping of property taxes?
Okay, a conveyance from Phil to the Phil Trust does not create an uncapping on it, and I do not lose the PRE. As long as I file the property transfer affidavit, okay? Most of the assessors indicate that they do not have the requirement to become knowledgeable about your trust if you choose not to tell them. And the way they do it is lift it up, and then you got to go in and appeal, and you win on the appeal, but you got to go through a bunch of hoops to get it there at that point. Now, on the property transfer affidavits, it's kind of weird. It's a revenue enhancement item in many areas. On residential, yeah, if you're short 10,000 in your budget, 50 PTAs into the basket gives you a balanced budget, okay? If it's commercial property, it's $1,000 per parcel for not filing the property transfer affidavit. So if you got 3 Sidwells, it's $3,000, okay, for failure to file on a commercial. So what we tell our commercial clients, if you hold the property in your own name and you're putting the commercial property into a trust, that's really mandatory that you put the property transfer get the property transfer affidavit filed. And remember, the assessors are getting copies of the deeds. And part of their job now is I have a deed, I don't have a property transfer affidavit, $200 residential. It's $1,000 commercial. It's something is being looked for because it's not a raising of taxes, but it's a raising of revenue. And that revenue stays with them. So it's a priority item in a lot of areas to look for that property transfer affidavit. Now, we try to have the buyers take it in, okay? Because they're a taxpayer and a voter. You guys may not necessarily be a taxpayer or a voter in that area or us. And they will always get the benefit of the doubt. And we always suggest they make a copy and have it stamped. That way they have proof that it occurred. If they're filing for their PRE, and we're coming up to the deadline, filing for a PRE, you want to make sure if they run in the last second that they get a timestamp so you know what occurred before June 1st.
What's the deadline, Phil?
May 31st.
What?
Yeah. Now, one thing too that I found that some agents are not using, where a seller is a seller here and a buyer there, they could get 2 PREs for 18 months on the house that they're selling, as long as it's listed on an MLS. Okay. When we pass that to the I'm on the Realtors Public Policy Committee, we put that provision in. Okay. And the argument is that way it's open exposure to the market. That's proof that it was. It isn't a $300,000 house that you put on the market for $800,000, just so you could get a PRE for an additional 18 months. But you can't occupy it and you can't rent it out. Rent it out, you lose the PRE.
No, that's okay.
Sold. But in particular on new construction, many people don't know to file for the PRE on the new house.
Say it again?
They can't file for a PRE on the new house until they have
Yeah.
a CVO or a
I do.
temporary CVO. So any of your new construction deals.
And
that
you know
had
what? You
in the
started
past
2.250.
No one was there at the final draw. You're there at the initial closing, and you can't file for the PRE then because you're not able to occupy it. It's only when the CVO is issued. So it's a good idea to confirm with your new construction clients that they have filed for the PRE And this is the perfect time to remind them. But that double list, the double PREs, I'm amazed at how many times people or how many agents are not making their sellers aware of that so that they can get the PRE on both properties. That 18 mils amounts to a lot of money.
So if it's a FSBO and there's an executed purchase agreement, but it hasn't been consummated yet, that works too for a double?
If they're selling, if their house is, their sale is a FSBO, okay, it's not listed with the MLS, so they don't qualify.
So if the seller buys a house before selling their
Right, which
existing.
just happened
right, so
yesterday.
it's
Yep.
conditional.
Decision is what the form is, it's a
Okay.
special form,
Right.
and then they can keep the two. That was a special thing that was done for the real estate community.
So that's another reason for them to list with you, so they get the PRE on the list on the sale property.
I'm looking just to make sure everybody's got that. There's no faces that are, no questions. Everybody's clear with that one? Because that's something, again, knowledge makes you valuable.
Yeah.
To throw out these kinds of things is something that doesn't normally happen.
Well, the worst thing is to have someone else tell them that they could have and you didn't. Okay, that's the worst thing.
How about the, because you see it being advertised all the home title lock,
Oh, yeah.
the seller
Without a
fraud
doubt.
thing.
I'm sure you do.
What's all that about?
Let me put it this way. I've told many people, I wish I had thought of it.
Mhm.
It's a no risk, all they're doing is telling you if something happened on your property. And guess how they're doing it? They plug into like Oakland County, who sends you a notice if something happens on their property if you register. And that's all they're doing, and they're getting paid monthly to do that. There's no insurance. If something happens, they're not liable for anything. All it is we'll tell you type of deal. And they're not liable if they fail to. So it's a great gimmick. Yes. It sounds like a whole lot more than what it is. We'll put it that way.
So talk a little bit about seller
What do
identity.
you,
then.
well,
Yep,
response.
well, Any questions on trust or estates or anything before we leave it? Seller identity fraud is the fastest growing claims item for title companies in the country. We used to talk a lot about fraud deals, and they occurred. Now there's a high frequency. Let me tell you a scenario of an actual situation, which was the broker was very lucky on this. The broker, or the seller was, the owner really was, $370,000 vacant lot sale in Bloomfield. The lister listed the property based on the quitclaim deed that the party brought in, said, we'll say Cheryl's the deed holder of record. I bring in a quitclaim deed from Cheryl to me. I say, here's my ownership proof. I don't want to record it because it may affect the taxes on the property by taking the cap off. I don't want to record it till the time of closing. Oh, that sounds like a reasonable reason. We list it. Okay, it's listed, and then it's sold for $370,000. $370,000 is wired to my bank account at, in this case, Capital One Bank. 9 o'clock closing, 10 o'clock wire, 10:15. Cheryl walks in to the broker's office and says, hey, I need to talk to the manager. There's a for sale sign on my lot. And Cheryl didn't sell the lot. She didn't sell it to me, didn't do it to anybody. But it was fortuitous timing that they're able to capture the money at Capital One Bank before it got actually dispersed to me in that situation. This is happening throughout the country. We're getting notices constantly of transactions to be aware of because they have found that it's a false seller. That it's typically going to be a vacant piece of property and the seller is going to be out of state. And they have the title, their title is just not of record yet. Those are the big danger signs. Had another one with it. I just did the program to an office in Clarkston, and next day, one of the agents called me, Phil, I think I got it here, one of these. Her dad owned 10 acres on Ortonville Road, and on M15, actually in Ortonville. That was zone commercial, and she'd been bugging him to, why don't you sell it? Because you're not doing what you intended to do with it. You say, "Oh, I'll get around to it sometime." Well, she's looking for some comps to tell them what the properties they're selling for. And she sees that property listed with somebody else. She called him up, "What are you doing? You didn't tell me you were going to sell it. And why didn't you list it with me?" "I'm not selling it. They didn't list it with anybody." Well, this is the problem of trying to catch the people on it, because now we knew we had a fraud situation. Brought in the sheriff's office on it, and the guys from Georgia that's selling it, trying to get him to come into the state, because the sheriff's office, in most any office, will not go out of state and use what's called the long arm statute on an attempted fraud. It has to be successful before they will do it. If we get him in the state, then they'll go after him for an attempted fraud. Okay, we could not get him to come inside the state, and then he eventually disappeared. But we called the broker who had listed it, and he was part of working with us to try to capture this guy doing it. But it's very difficult to catch the fraudsters. You read about all this safeguards on the driver's licenses and everything. That additional safeguard is what made it roughly 25 minutes to create a duplicate license instead of 2 or 3. Okay, it's not a safeguard that is truly a safeguard in all situations. But the fraudulent documents that are being created are just unbelievably good. It's when we remote closings always have that problem of what's the idea? Oh, the driver's license and all that. Well, we may have pictures of the driver's license, but too bad it's not a real one. So you don't have your proof of ID. So we're going a lot further in trying to identify who the seller is in those situations to make sure that it's not being sold out from underneath the real owner.
So Phil, from an agent perspective, what should we be looking for, doing? What's a red flag that might help us? Obviously, if we know the people, it's one thing.
Yep.
But when we don't know someone,
Well, typically it will be someone from out of state who has a vacant piece of property. That's the two most common elements. Now, we've always had what we refer to as the snowbird sales problem, where typically it's a cul-de-sac property. End of the cul-de-sac, people go to Florida for the winter and you get the call, okay, we've decided we're not even going to come back to Michigan. We want to sell the house and the contents, and we want to sell it quick because we got a great deal on a house down here as long as we can close quick up there. So the house is listed for a lot less than what it normally would be with all furnishings included. Those are the ones we look out for. When we see all furnishings included, et cetera, we may ask a few extra questions because that may well be one of the snowbird sales. Now, Florida, ironically, has the reverse. They have the summertime sales where the people who have a winter place come back up here and then their house is put on the market there while they're gone. Actually, Florida has a far bigger problem than we have here because the people don't know each other that well, really, and the houses down there. And anyhow, it's one of in Florida, I mean, that's something, you talk to any agent down there, they're always talking about the absentee sales where the seller isn't participating, shall we say. So anyhow, look out for the out-of-state owner, particularly a vacant piece of property, or if they're selling everything included. Now, if it's a state situation, okay, and they'd rather not clean out the house, so you take it as is, that's a different situation than we're selling with all furnishings. I question that because it is something that's running rampant through the country. I don't care what title company you talk to, this is an issue.
So here's Ladybird deeds are always a wonderful topic.
Yep.
So here's a question. How long does a person, it's actually two questions. How long does a person who inherited a property through a Ladybird deed have to still have the PRE?
If the deed goes from me as granting it to my son Jason. Okay, that will be his, upon my passing, it's his. But I reserve the right during my lifetime to do anything I want to do with the property. And that will break off any interest he has. That's a typical ladybird deed, where you're in essence creating an in limbo conveyance. As long as you're still occupying the property, you get I get the PRE. Okay, if I move into assisted living and they have that ladybird deed there, theoretically I lose the PRE because I'm no longer living there. Okay, now there's a provision that if you're only temporarily in assisted living, that you can keep it. But rarely do we see somebody go into assisted living and go back to the house. Maybe a wound care center that they go into temporarily, they get to keep it, but not an assisted living center. So a ladybird deed is a way to avoid probate. Okay, but if the estate is large enough, it doesn't avoid the tax. Okay, if it's over $1 million, then it's a target file. So that could well be a taxable, a part of the estate at that point, at the point of death.
So in the case where her lady just passed away,
We are coming up to the end of where homestead would be. Should they file, should they remove the homestead, what should they be doing?
So just to clarify, so everybody knows, when we originally started, we talked about somebody who just got a listing, got it sold, durable power of attorney, and then the person who granted the DPA actually passed away. So that was, now they've got to go to probate, letters of authority,
The target date was the 23rd.
target date of closing before the end of the month.
Good time. Don't push it further. Okay. Theoretically, you lose the PRE when the person passes away because they're no longer residing in the property. It's rarely enforced unless it's a lengthy period of time afterwards, or you start making all kinds of improvements to the house to resell it or just sell it. Then that will catch the attention. But in general, it does not, you do not lose the PRE as long as you're selling it right away. And then obviously the new buyers need to file for their own PRE.
So, and that was kind of the follow-up question, if I'm right, because she's put, should the person who is named receive the property in the Ladybird record, record the death certificate right away or wait for the sale of the property?
Well, depends on how much you like paying extra tax. And that's in all reality. I mean, if you shove it in the face of the assessor, yeah. That's, if you just kind of skate along, I haven't seen anyone go back after them in those situations. Doesn't mean they won't, I just haven't seen it, okay?
Let's see, we've got guardian and conservator have a listing signed and PA signed. Ward passes, where are we at?
If it's okay, first of all, a guardian can't sell property, okay? Guardian is for personal assets. It has to be a conservatorship to sell property. So the conservator's signature binds the person because the person no longer has a right to act on their own. When they have a guardian and conservator, their signature means absolutely nothing. They have the legal incapacity to do anything. So it's the conservator's signature that counts. If there's a binding agreement, typically it will be binding upon the estate also, because now you're opening an estate and the conservator acted for the deceased, who it's now their estate, so that agreement is still there. Now, sometimes the courts, if they're, we don't know why, sometimes, will not necessarily allow that listing to stay in the place and treat it as being binding, and the court's ruling is final on that. But it's well, I shouldn't say final. You can appeal it, but usually it's just an exercise in paying legal fees. It's nothing more. But the conservatorship is, at least in theory, binding upon the estate, the act of the conservator. Any other questions on that?
Guys, I got a whole bunch of people here in Lake Orion. Anybody out there who might have questions?
Speak to what you guys are seeing in as far as legal action that's been going on. Is there something that we keep seeing? Is there something that I know that just myself in the last couple of years, we've had a lot of claims of failure to disclose. What are we just kind of seeing as far as what are the things that are going to court? What are the things that are being disputed on a broader level?
Well, first of all, the seller's disclosure statement is your best friend, okay? And don't ever fill it out yourself for the seller, okay? Otherwise, you're covering the seller's problems at that point, potentially. If the seller has disclosed it or said that they don't know, they're probably okay. But if they received a notice from the health department that their septic tank is tested bad and they have to replace it, that is a disclosable item that the seller has to disclose to the buyer. If you know about it and you fail to disclose it, that gets you into a little bit of a problem too, because you have actual knowledge of it at that point, not just imputed through the seller. So anything that would cause the seller a problem, like leaking, bad foundation, leaking, whatever, it's one of them that I was involved in, the house was sinking and they went in and put jacks in and jacked it up. Now, I don't know who the inspector was to use, but he gave a clear passing on the house with the jack sitting there. And that's something that is something that the buyer was not able to sue on, because they were buying the house as is, and they didn't put a wall up to hide it from anyone seeing it. It was, the jacks were there, they had an inspection done. There are all kinds of ways that the buyer could have known at that point, and the seller did not hide it. Now, if they put a temporary wall up so you couldn't see the jacks, now that would be a problem for the seller, because they're actively concealing a problem at that point, and they'd be liable. But the foundation problems are when the inspector that you refer your buyers to is very critical on that. Now, along those lines, one quick thing we're seeing a little bit more of too, because of West Bloomfield starting and now going elsewhere, another revenue enhancement item for a township's building department is if you put on there newly remodeled, okay, what's the first thing you do? Any permits pulled? Oh, no permits. Okay, so now you get charged the permit fee, you get the penalty for failure to failure to get it, an inspection fee, and a failure to call for an inspection. And it's happened in one house, foreclosure property in West Bloomfield. The buyers denied West Bloomfield access. So you know what they did? They red tagged it. And all the people had to be removed from the house immediately. And they came in and to check the plumbing and the electrical, they had to make holes in the drywall to see that. It was a very expensive item. So I know many agents now are when they're on this buy side, are checking to see if there are any open permits, because if they haven't pulled the inspection, that's still an open permit. And to basically representing the buyer, you want to have all of the permits closed out by having a satisfactory inspection. Because but again, it's revenue enhancement. You have to keep in mind that building departments don't have as much building going on. They'd like to keep the same number of people and pay them the same money. So therefore, they need to collect it some other way.
So one of the things I'm hearing you say is that we shouldn't just be sending over seller's disclosures without looking at them ourselves to see if there's something funny, like, did they actually pull permits on a property that's been flipped?
Yep. Or if you see that it's a modern, that they've modernized it or remodeled, whatever, that's a big red flag to the inspectors. It should be a red flag to you as the buyer's agent to see what permits are still open.
So I know the answer to this, but I think it's best coming from you.
Oh,
If
okay.
I flip the property, but I've never lived in the property, what, can I, as that individual who's never lived in that property, am I exempt from the state mandated seller disclosure?
In theory, yes. In court, no. Yeah, because if you're actively concealing something, that's the critical part. Are you actively concealing something? And particularly if you are a licensee, okay, that's where it becomes a problem because you know better. If you're a member of the public and say, I didn't know, you might get away with it, but not as a licensee doing the flipping.
And it was interesting, I actually showed one yesterday and somebody had completed the form and all was all unknown. Which, how many people know absolutely nothing about the property? So even when we do educate them and you see them going unknown, you might want to consult them. Because do they truly not know anything?
Well, you run dangerously close to practicing law. But you might even say that you might want to talk with your attorney about what you want to disclose on this seller's disclosure statement if you're only comfortable putting on knowing. It may affect what the buyers think about the property too. That you can say, because that's value. Okay, as far as the legality, you might want to refer them to their attorney to talk about it.
Well, another thing, no, is that I believe you'll find in all the packages, the exemption form to the state seller's disclosure. Because then they can check off which one applies to them. If they
Yep.
say that I'm exempt, great, which one of these applies? Have them initial it, sign it, and put it part of your package.
More often in that case, we see them sign it with nothing there
Yeah.
and I never lived in it.
Yeah.
Now, those are the situations, obviously, where the quality of the inspector that the buyer chooses becomes very critical because you have nothing to rely upon as far as representations from the seller in those situations. Your inspector is going to be the one who determines whether or not there are problems, and they have to find them independently. They're not going to be able to see that the seller had a leaky roof and, or whatever, and that's what they repaired it. The inspectors we're seeing are more and more critical on the purchases because the sellers are more and more knowledgeable of what they don't want to talk about.
Back on that, one of the things that I hear a lot is after a home inspection, what, if ever, makes the seller required to change their seller's disclosure? So what information, because obviously a home inspector is not a licensed contractor.
Yep.
What is the duty of the agent there? And where does the seller's duty to disclose change after a home inspection? They've been notified of certain things.
They really have no duty because they filled out it as the information that they knew at that time. I've seen some go through and put redisclose on it, but now they're, okay, do they have to take the whole inspection package and go through and make sure they caught every item that the inspector said might be wrong and put it into their disclosure? I don't think any seller should change it.
Post office is
Oh, well, I think sometimes inspectors put it in so there's a reason to decrease the price for the seller because they found mold. Okay, it's that more and more times I think the inspections are done to find at least a basis for countering the, particularly if they offered over the list price to have the best offer. And now want to get that price back down because they found out from the bank that they can't mortgage 80% of what the over list offer they made.
So question on here, we have, and I think, Rich, you're saying that we've added this to a purchase agreement. Purchase is as is, where is, with no warranties expressed or implied. Any requirement to obtain a certificate of occupancy is the burden of the purchaser. Is there any problem with that?
Nope. As long as you put it in there and as the purchaser beware, that's when you check to see if there are any open permits.
Yeah.
Okay, yeah, for sure. That's kind of your tip off that there may be some.
Yeah, like heads up.
Yeah.
So the question on the seller disclosure is, was there any work done without permit or a licensed contractor? Seems to be a big hole, big enough to drive a semi through.
Usually marked on no one. Yes.
Normally marked unknown.
Now, just as an aside, many of you have heard me talk about the extended coverage policy or Eagle policy, whatever. Okay, that this is the one time that that policy makes more sense than a policy without exceptions. Because that extended coverage policy covers failure to pull permits or inspections. And so it is an item that is good in the extended coverage policy. Now, the policy with standard exceptions deleted, at least the two big ones, which are the survey and any restrictions or whatever that may be in place. But the survey is the big item. But if your issue is a survey, the extended coverage policy, I think false coverage because it's a $2,500 deductible with a 10,000 max. Okay, so you have limited coverage on a survey error or an encroachment problem like the house is on the adjacent property under an extended coverage policy, whereas a policy with the standard exceptions deleted, you have $1 coverage for whatever it is. Okay, so if that damage is going to be 40,000 to repair or to buy that additional land from the neighbor, okay, that is covered by a policy with the standard exceptions deleted. On an extended coverage policy, it's a $2,500 deductible with a 10,000 max. So you're not, depends on what your issues are as to what's the better policy to have. But if it's a newly modernized or whatever, the extended coverage policy, I think, is a good one to get because it does cover the no permits pulled or no inspections.
Does.
Yes.
Yeah. In all honesty, but for that item, it's just a chance to collect additional premium. You get better coverage under the policy. The standard exception is deleted for a lesser fee.
New construction, does that qualify for it, or does, like LLC, as a purchaser?
So can you give what the two policies are again?
Okay. Well, let me give you three. There's the standard policy, which has certain standard exceptions, amongst which are items that would be disclosed by an accurate survey, which is the most critical item. The standard policy with standard exceptions deleted deletes that survey exception. The extended coverage policy covers you on it with a $2,500 deductible and a 10,000 maximum liability. So if the survey is the issue, you don't want the extended coverage because you're getting limited coverage. You want unlimited from $1, which would be the policy with standard exceptions deleted.
Very good. Well, gang, because it is Hot Topic Tuesday and we got you a twofer, I got 11:56. I want to give everybody a little bit of a break before we kick in at noon with our AI magic for real estate. So everybody go ahead and take a break and we'll get kicked back in at noon. But so Phil can see y'all. Everybody give Phil a big round of applause and appreciation, right?
Thank you.